Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
All right, welcome to our Curious Amalgam. I am Puja Patel, and today's episode is titled, Is Antitrust Fashionable This Season? Antitrust in the Fashion Industry. I'm here with my co-host, Jeny Maier. Hi, Jeny.
Hey, Puja, how are you?
Doing well. Can you introduce today's guest for us?
Absolutely. This is going to be a really fun one. Today, we are joined by Andowah Newton, who brings a really rare combination of both legal acumen and fashion and luxury industry experience, including she spent some time in-house at LVMH, Moet, Hennessy, Louis Vuitton, and 8 years as a big law litigator with other clients in the luxury industry. So brings a lot of great industry knowledge here. And as LVMH's U.S. VP of Legal Affairs and Head of Litigation, Andowah oversaw and managed a broad range of matters, including several antitrust investigations in the luxury and fashion industries for 8 years. And she also has some great experience in the luxury, technology, entertainment, media, and consumer product space from a previous accounting career at Estee Lauder, PwC, and Johnson & Johnson. So really excited to hear her perspective and talk about how antitrust law is reshaping the luxury sector. So welcome to our Curious Amalgam, Andowah.
Thank you so much for inviting me. I'm excited to be here.
So in this episode, we're going to explore how antitrust principles are being tested in the world of high-end design and fast fashion. We'll walk through some of the more headline-making cases and emerging trends that are forcing antitrust enforcers, courts, and private litigants to reckon with what competition really looks like in an industry that's built on branding, exclusivity, and status. Jeny, do you want to tell us a little bit more about the cases we're going to highlight?
Yes, thanks, Puja. So in the last couple of years, we've seen a really, kind of increase in the notable antitrust cases that intersect between the fashion and luxury retail industry, notably the FTC's merger enforcement action against Tapestry and Capri related to Michael Kors and Coach handbags, as well as a class action litigation that alleged no-poach agreements between Saks Fifth Avenue and certain luxury brands that were in their stores, as well as an antitrust litigation against Hermès, alleging that the company unlawfully tied purchases of its very famous Birkin bag to the purchase of other Hermès products. So, Andowah, maybe to just set the stage, why do you think that antitrust enforcement is suddenly a hot topic in the kind of luxury and fashion industry right now?
So I want to confirm first that previously it was a sleeper industry from an antitrust perspective. The fashion industry and luxury industry somehow kind of flew under the radar of regulators and in several types of regulators. So it's really interesting to me because right now, the latest stats, but luxury has about a $70 billion market cap in the United States, and fashion has about a $370 billion market cap. So it's surprising that there haven't been more issues that have risen to the surface earlier on. I think that both markets, consumer markets, financial markets, and government agencies are awakening to the reality and the level of wealth acquired by the luxury and fashion industries, especially the big players. And then when you have events like the luxury CEOs being, in one case, the world's richest man in the world a couple of years ago, and another one marrying celebrities like Salma Hayek, you have even more visibility that's focused on the industry. So people are paying attention to both industries. And the last aspect of that, I think, to highlight is women being on leadership at the commission, and both you and Puja could speak to that. But I think, for example, in the court decision that we'll get to, when the judge there, who is also a woman, speaks about the necessity of handbags to women's lives, and you get that incorporation of how important a role accessories and fashion items play in people's lives, particularly women's lives. When there are more women in leadership, I think it tends to affect the scope of what's looked at.
It's a really great observation. And I remember very vividly some of the comments that the judge made about, what is a handbag and why is it important to women? We'll probably talk about that in a little while, but that's a really very interesting observation. Do you think that there has been increasing consolidation in the space? And what do you think of that trend?
Totally, just not just in luxury, but in retail generally. When we look at Alberts and Kroger's, the attempt at that merger, for instance, but all over the retail industry, there's consolidation. I think they're the typical forces at play, like pricing competition, supply chain issues, labor demands, of course, but particularly for luxury brands, I think that brands, fashion companies are closely watching and attempting to emulate the big players because they've had so much success in achieving the market share and building wealth. So I think newer brands or even brands that have existed for a long time but just want to have a strategic advantage are looking to the business models that worked for those top players and trying to emulate them through consolidation. So I definitely think the trend will continue. And when we look at, kind of another bend on one of the issues we'll look at later today is, looking at Prada's acquisition of Versace, for example, from Capri recently would be an example of some of that consolidation happening as we speak.
So, with, these, especially in the luxury and higher fashion industry, so what stands out to you about how competition is understood and how sort of market power is understood while some of these brands are very, high status, they are, sort of comparatively, small compared to some, broader companies that exist in the space. So, how do you sort of see competition and potentially market power playing out in this space?
Yeah, well, I think that there's a huge dichotomy between the large players and kind of the big dogs in the industry versus the smaller players. And the larger ones, of course, have had an eye on the competitive edge that can be gained through mitigation of competition or through market power and market share. The smaller ones, however, I think these concepts are becoming more prevalent and they're becoming more aware of as time goes on, that growth isn't just achieved internally, but when you kind of max out on that internal growth or kind of run out of ways on how to strategize to revitalize a brand, that acquisitions and mergers can be looked at to achieve that type of growth. That's from a commercial perspective. I think legally, the smaller brands have a lot to catch up on in terms of just figuring out what the regulatory landscape looks like on these issues. I think probably a lot of fashion and luxury brands haven't even heard of the concept of antitrust. So there's probably a lot of education that could go on in that space. And I think with these kind of high profile regulatory decisions coming out, that will change over time as well.
So before we jump into some of the specific cases, maybe based on your broad-based experience in the industry, what are some of the issues, antitrust issues that, you sort of see recurring sort of regularly that, in a, in-house role, you think, people should be paying attention to?
Well, as we'll see from some of the cases that we're taking a closer look at, definitely pricing, marketing techniques, sales techniques, and also relationships with vendors and third parties, distributors, the channels. All of that, I think, is kind of up for being under scrutiny at some point or another. So, as Puja kind of alluded to in her intro, the concept of luxury is so intertwined with exclusivity. So it's going to be fascinating to see how regulatory authorities balance those concepts in evaluating competition in the context of luxury.
Andowah, I want to move to some of the high profile cases we've talked about a little bit and to get your reaction being in the industry. Us antitrust nerds have talked about these cases over and over ad nauseum, and I would love to hear your thoughts being in the industry, getting your perspective. So maybe first we can talk about the Tapestry Capri case. And for listeners, the background here is this was a case brought by the Federal Trade Commission against the merger between Tapestry and Capri, two well-known luxury brands. In October of 2024, the federal court granted the FTC's grant for preliminary injunction. So the court decided to block the deal. And the key issue in that deal was around the concept, what the proper market definition was. The court sided with the FTC's view that the deal would reduce competition in what they called the accessible luxury handbag market, a segment that sort of sits between mass market and high-end luxury products. And within that market for accessible luxury, the court found that combining Tapestry's Coach brand and Kate Spade brands with Capri's Michael Kors brand would result in a roughly 59-60% market share between the two parties, leading to higher prices, reduced innovation. And in the decision, the court heavily relied on internal documents that suggested this sort of accessible luxury market. And as a result of this decision, the parties did ultimately abandon the transaction. So, Andowah, I want to ask you, what struck you most about this market definition? Is accessible luxury a submarket that you have seen in the industry from your experience?
So for me, I think it's more about nomenclature. I generally, in the spaces that I was in, generally never heard the term accessible or affordable luxury at all. And that's presumably because I was in what the court and some of the experts in the case refer to as the true luxury spaces. So, but internally, I would say that the spaces that I was in, we thought of ourselves as just luxury, nothing else. So from a concept point of view, I would view some of the brands that were at issue in that decision as just non-luxury or middle market. I think that the term accessible or affordable luxury, and some of that is referenced in the decision itself, is kind of a marketing hack, basically by some of the middle market brands to associate and kind of get themselves closer to luxury. But when you think about some of the items highlighted in the decision, exclusivity, the way something is made, the material it's used, where it's made in, to me, there's a huge distinction between luxury and non-luxury. But again, I think that's only in terms of nomenclature. I think the court got it right in terms of describing this other market out there that's middle market, the way she captured it in terms of the pricing and what it's meant for and the quality achieved at a lower price point. I think she captured the right concept. I would just call it something different. And there's another aspect that I would probably add. I think that there's a little bit more nuance there between what I would call middle market and luxury. There are some brands that straddle, perhaps Versace is one of them, or Marc Jacobs is one of them, the middle market and luxury markets, in a way that the others don't. I think the others more clearly fall into either the category of luxury or middle market.
And what is your take on the competitive dynamics between Coach, Kate Spade, Michael Kors? Are these brands really substitutes for one another, or are they each their own unique exclusive brand?
From my understanding of antitrust law, I think for legal purposes, I think that they are effective substitutes. I don't think that they are actual substitutes in terms of the consumers, but in terms of the analysis, I do for those specific brands. I think that as you kind of go up the luxury scale in terms of products being considered more luxurious or more definitively as part of that luxury category, there's a lot of a strong brand identity associated with those true luxury brands. And as you go down the scale and work your way back into the middle market, there's less of a strong brand identity associated with each brand. So for those few brands highlighted by the court, the Michael Kors, Coach, and Kate Spade, I think there is some kind of interchangeability. In other words, a customer might more likely purchase another one of those products in terms if there's a better price, they might switch between those brands a little bit more readily than they would, let's say, one of the true luxury brands, where they're attached to not only the name, but the history of the brand, or perhaps they identify with the chief creative designer of the brand. And so they have a personal connection with that. In the middle market brands, sometimes you can find some of that consumer sentiment. I think it's not as strong. So other factors like price might have a heavier fact, might weigh more heavily in their decision making. So yes and no. I think it's a complex question, and it's not to say that Michael Kors and Coach and Kate Spade don't have their own kind of brand identities. Some might say that Coach has a kind of more classic conservative feel to it, that Kate Spade has a very definitive feminine aspect to it, that Michael Kors is very bold in terms of its colors and very kind of classically American. So there is some of that, but for the analysis purposes, for the legal analysis purposes, I think the court got it right here too.
Last question, Andowah, before maybe Jeny can cover our next case. We're 6 months out from the court's decision and the party's abandonment. How has this decision, if it has at all, reshaped the way luxury players think about growth, that, in terms of deal making versus organic growth? Have you seen deal making slow down because of this decision?
Well, I think that, for example, we already mentioned the example of Prada purchasing Versace, and that is very interesting to me, because I wonder how this decision would have played out had the brand portfolio been slightly different, right? Like if you were to replace certain brands with a Maier, Tapestry, or Capri with others, would the same analysis have been applicable? So I think those are probably the same issues that players in the luxury and fashion fields are struggling with or grasping with right now. What makes sense in terms of proposed transactions and growth, and to take a closer look at defining what their true competitors are. Often you might define a competitor as one thing or the other for marketing purposes, but it's not the same thing necessarily from a strategic growth perspective, or from a long-term strategic perspective of how you envision a particular group or brand becoming. And it may make them think harder about how they can revitalize a brand, about maybe making a commitment, and a financial commitment and an operational commitment to create growth internally, and making bigger and more intentional changes to their existing brands, rather than trying to achieve that through combinations.
Interesting. So wanted to then maybe segue to, a different topic. You mentioned earlier, Andowah, that, one of the real common, things that comes up in, counseling brands is, sort of dealing with, distribution and how you get your products to market and how you market them to individual consumers, in retail stores or otherwise. So let's talk about the Saks Fifth Avenue, the no-poach case. So just as a recap, in March of 2025, this year, the Second Circuit Court of Appeals had upheld the dismissal of an antitrust class action that was brought by a number of former Saks Fifth Avenue employees. And in that case, those plaintiffs alleged that Saks and several luxury brands that were sold in Saks stores, including Louis Vuitton, Gucci, Prada, Loro Piana, Bruno Cucinelli, and others, had entered into no-poach or no-hire agreements, which prevented those brands from hiring Saks employees within 6 months of those employees' departure of Saks without mutual consent from Saks. And so in that case, the court had determined that those agreements were so-called vertical in nature rather than horizontal, because these agreements occurred allegedly between, a retailer and its suppliers, and therefore the court found that they were subject to the rule of reason in the antitrust terms, rather than being deemed, per se unlawful. So given the application of the rule of reason in the case, the court found that the plaintiffs had failed to demonstrate that these alleged agreements had any actual adverse effect on competition in the labor market. And so the Second Circuit affirmed the district court's dismissal of the case. I think notably the case got support from both the Department of Justice and a number of state attorneys general who had filed amicus briefs asking the Second Circuit actually to revive the case. The Second Circuit still found the plaintiff's allegations, insufficient to state a claim. So after the Second Circuit decision, the plaintiffs had voluntarily dismissed their case, and at least as of now, the litigation is no longer going forward. But to get your perspective on, what about these sorts of, arrangements in the labor markets in this particular industry, what do you think got attention of, kind of the private enforcement bar?
I think that in reading a little bit about all of the changes that are taking place in the antitrust space, as we explored, Jeny, when you and I did the panel at a conference last fall, and that required me to get up to speed on a lot of things that were taking place in the antitrust world in the past couple of years. But between the merger guidelines and different pronouncements that have come out, I think this idea that the DOJ and FTC will be focusing on things like impacts on the labor market as much as impacts on consumers going forward, if that's still the intent, probably caught the attention of the plaintiff's bar, would be my guess. And so decided to go down that path and testing the extent to which that's going to be true or going to be important both to courts and enforcement agencies going forward. And then I think just the realities of where we are in terms of the recent economy, not just right now, but over the past several years, there's been a lot of concerns about unemployment and pressures on the labor market and just disparities that we haven't historically seen in the US economy in terms of great statistics for labor, but then really poor statistics for labor, depending on the way that you cut and slice it. So this kind of shift to viewing antitrust through a labor lens, to me, makes sense. I think probably, as the Second Circuit said, the plaintiffs here could have done a much better job of presenting the evidence that was leading to their claims. However, the claims at their base, I think, are worthy of a serious look. I think the relationships here, and particularly in the luxury and fashion industry, are often a combination of both vertical and horizontal arrangements, in the sense that a lot of the brands, I think every one of those brands that's named as a defendant has their own standalone retail stores. So their relationship with Saks is unique, or at least blended. It's not purely vertical or purely horizontal. And I think that future decisions in this field or in similar fields should take that into account when sufficient evidence is provided to demonstrate how the practices might be violative of the antitrust laws.
Based on your sort of knowledge and experience in the industry, do you believe that these, types of sales employees, have kind of specialized knowledge that they get from, working in these particular environments that, might actually justify a, employer in wanting to, sort of restrict their ability to go work at a rival?
Justify, I don't know, is a strong word, but certainly it would make an employer concerned, because of course there is the nature of the luxury industry is so customer specific. It's about knowing the customer's needs and wants and developing that relationship over time. In the industry, when there's an approach to a customer in a retail space, it's referred to as a sales ceremony rather than just a sales transaction. So just that terminology right there indicates to you the level of personalization that's involved. So I'm sure that there are reasons to be concerned about employees going from one competitor to the other. But from a labor perspective, it's also important to realize that these employees are developing specialized knowledge in the luxury industry, and it's really hard for them to go elsewhere out of that because it's so particularly to the luxury industry. And given the volume of sales in the luxury industry, there are not too many places for them to go. And I think we were talking the other day about the fact that a lot of the big retailers in the luxury space have disappeared over the past couple of years, whether it's or reduced their presence, whether it's Neiman Marcus or a whole bunch of former big shops. So Saks, I'm not sure that Saks in and of itself has a true competitor anymore as well.
Interesting. So maybe sticking with another case that also relates to a particular luxury brand and retailer, talk about the Hermès case, and just for our audience's familiarity. So in March of 2024, Hermès was faced with a class action lawsuit in Northern District of California. And in that case, they were alleged to have violated antitrust law through what's described as unlawful tying practices. These consumers who are plaintiffs in the case claimed that Hermès required customers to purchase other products like shoes or scarves or jewelry in order to build a sufficient purchase history before they were granted the opportunity or privilege to buy a Birkin bag or a Kelly handbag. And in that case, the complaint alleged that this practice sort of leveraged Hermès's market power in the Birkin bag market in order for them to boost their sales of these so-called like ancillary products, and alleged that this sort of inflated the prices of these ancillary products and limited customers' choices. So one of the other allegations that I thought was sort of interesting in that complaint was that they alleged that Hermès's sales associates had received extra commissions on the ancillary products, but they didn't get commissions on the Birkin bags, which allegedly incentivized them to try to enforce this alleged tying agreement. And earlier last year, Hermès had filed a motion to dismiss the case, basically alleging that or challenging the tying agreement and its cause of any antitrust injury. And in the case, Judge Donato in California had expressed some skepticism of those claims and had dismissed the case. But just understanding the allegations there, I think, were something pretty interesting, but wanted to get your thoughts on sort of how this case could be causing impact about how using exclusivity or making a product hard to get is a sort of viable or good sales strategy.
I think this decision will tell us, will let us know. I think it's important to think about exclusivity and in several aspects. I think traditionally it was not something that was manufactured or artificially created. Traditionally, it's something that was just a pure reflection of the quality of the product, the demand that was created based on the consumer's desirability of it. And so it was more of a process of the product proving itself to the customer rather than the other way around. And since then, of course, some strategies have developed that I would call midway strategies to kind of create or influence this aspect of exclusivity. So very high pricing or producing in limited quantities or creating limited editions of certain products. And I think for the most part, those have been deemed okay by courts or the regulatory authorities. The strategies that are alleged to have been used in this matter seem to me pretty aggressive compared to the traditional just occurrence of something becoming exclusive or these midway strategies, particularly this tiered structure where certain products corresponded with certain sales commissions and ending with the Birkin bag being a 0% sales commission. To me, that's a very stark incentive to kind of create this faux exclusivity for a product. And I'm not even sure that it's necessary given the dynamics around the demand over the Birkin bag. So depending on how the court decides, I think probably a lot of brands are eyeing this decision. I have certainly been asked to consult about the impacts of this decision, but I think a lot of brands will either become more aggressive in terms of what they do to create this exclusivity around their brands and products if the case is dismissed, because I'm sure some brands were reading this and were surprised at the extent to which these tactics were used and said to themselves, hey, why aren't we using some of these tactics with some of our more desirable products? On the other hand, if traction is gained, whether through some kind of meaningful settlement or continuance of the litigation, I think that will kind of cause brands to tamper down a bit in terms of their strategies if they are using similar aggressive tactics to retain or create exclusivity.
Andowah, thank you for this. Maybe just to close out some broader takeaways from these cases, do you think there's a reason we're seeing a trend of increased scrutiny in the luxury and fashion industry? Or are these just isolated cases that don't necessarily sort of have predictions for future enforcement?
In addition to some of the reasons that we talked about before, just kind of both business markets and regulators opening up to the knowledge about how dominant the luxury and fashion industries and how successful they are in terms of building wealth for their owners. I think another thing that was revealed through, for example, the Capri Tapestry decision was the profit margin. Luxury has a very high profit margin compared to most consumer industries. The court cites 60%. I think that it can often be much higher than that, depending on the product and the particular luxury industry. So with that kind of profit margin, I think that it will only, now that the cat's out of the bag, I think it might only increase the regulators' interest in scrutinizing this and related industries.
What about sort of on the opposite end of the spectrum from luxury, fast fashion, which may have lower margins? But do you see that side of the industry becoming part of future antitrust scrutiny?
Definitely, just because of the popularity of it. It's interesting. I think sustainability in and of itself has already caught some regulators' eyes in terms of the concept of greenwashing, which I did a presentation on a couple of years ago. There's been tons of enforcement and litigation in that space, not only domestically, but internationally. And fast fashion, just given that it's on everyone's minds, especially young people's minds and habits, I think will get some attention as they take away market share from both middle market and perhaps even luxury. Kind of young purchasers were and have been a direct target of the big luxury players, but fast fashion is getting a piece of that market as well. And I think, ironically, both sustainability and fast fashion are in direct tension with each other, but younger consumers are demanding both to increase levels. So we'll see kind of who wins that fight and how that plays out in terms of the regulatory action.
And what do you think in-house counsel at these luxury brands should be thinking about and worrying about in terms of some of the key hot button competition issues? Algorithmic based pricing, resale markets, exclusivities, dealing with online influencers. These cases just show the breadth of the issues that are at play here. I'm curious what you think should be top of mind for in-house counsel.
I think, Puja, you hit the nail on the head. There's such a variety in scope, and the cases that we highlighted are just examples of those. So they should keep an eye on all of the above. And I particularly have delivered a number of presentations on AI and tech and how that has implications on litigation. And I think that something that strikes me is often the legal team is not necessarily fully aware of how businesses are using new and emerging technologies in their everyday business. And the litigation cases that I've reviewed and analyzed, a lot of them deal with not just big generative AI companies using AI, but in normal run-of-the-mill companies in any industry using machine learning, algorithmic pricing to achieve certain market share or to affect their pricing or to make important decisions relating to consumers. So I think it's important for in-house counsel to get a grasp of what the business is using in terms of tech and AI as they move forward, not only internally, but how customers want them to be using it, vendors and business partners, and to determine how they're going to either make disclosures about that or require their business partners to report to them about how the technologies are being used.
Andowah, what's one bit of advice, tip you have to give to in-house counsel in the luxury retail space today?
Well, this is going to seem obvious after this talk, but carve out some time to get up to speed on antitrust law. Definitely. It's not something that I thought I would be focused on when I was in law school or even when I knew that I was going to be in the luxury space as a lawyer. But the amount of activity that I saw and the amount of times that I've spoken about it since my time in the luxury space is astonishing to me. So I remember the first time an antitrust matter came across my desk, the first thing I did was called a former firm colleague who was the antitrust woman. That's all I knew about her. And I called her and I was like, what are like the 5 primers that I need to know? So she immediately forwarded me some DOJ stuff, some SEC stuff, and I just had to get up to speed. And I encourage everyone in working or desiring to work in these spaces to look at antitrust as well. It's very prevalent in this industry now, and I think it will only continue to be so.
Awesome, Andowah. Well, we really appreciate your perspective. It's really fun to actually have an opportunity to get to talk to people who lived and breathed in the industries that we as outside antitrust lawyers kind of see a little bit from afar, but we're really thankful for your insider point of view. And as we wrap up our episode here on our Curious Amalgam, we like to end our shows wanting to get to know you a little bit better as a person. So, the question that we always ask each of our guests to share with us is just tell us something about yourself that we would not know if we only knew you in a professional setting.
So I was going to say for this question that I'm a huge opera lover. I'm a wannabe opera singer, and that's my go-to passion. But then I figured that there was something actually more directly relevant to everything that we've talked about. No one would guess this about me, but I was a bit of a gamer in my younger days. So I won a countywide championship twice for Super Mario Brothers 2 and 3. So that'll tell you the time period in which we're talking about. And I was so proud of that because it gave me a certificate. I won a certificate to Benetton. Remember Benetton? And I was so proud of myself for that. But I mentioned that because I think being in that kind of gaming space, I had 4 younger brothers. A lot of my best friends in high school were guys, and we were, always playing these games. But I think it sparked my interest in technology. And, since then, and now being in the legal field, I've done a lot of speaking on tech and AI, and it just makes me a little bit less afraid of approaching those issues as I think a lot of our lawyer colleagues are. And so you never know what angle the things that you're interested in as a kid might contribute to your future pursuits.
I love that. I'm going to ask Andowah a question. We call this segment our Curious Hat, where I'm going to ask you a question that we haven't told you about to help learn a little bit more about you. And the question is, if you had $50,000 to spend on the condition that you have to spend it all in one day, what would you spend it on?
Oh my goodness. Oh. I've always thought when I was when I was graduating from law school, I wish that there were a way to attract young legal graduates more easily who are worried about debt from law school, but want to do good out there into either government jobs or private interest jobs. And I know a lot of schools have implemented programs that help with that. I know I went to Cornell Law and they have like a public interest fellowship program. But if there were some kind of fund that could be established that would make that burden easier, and that could be scaled or duplicated, not just $50,000, obviously it would take a lot more, but to kind of level the playing field in terms of people who want to, work at a DOJ or an SEC or an FTC and in their future, but, can't really afford to take the steps that would lead them down that path. I think that's how it's funded.
A very noble answer and a very positive way to end our episode today. So, Andowah, thank you so much for joining us, and thank you, listeners.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.